This episode of the Etsy Conversations podcast is sponsored by Etsy Success Strategies, the audio series. Subscribe to these premium podcasts and listen your way to successfully selling on Etsy. If you struggle to keep up with the Etsy Success emails and other educational materials from Etsy, or if you've fallen behind in going through the seller handbook, then sit back, press play, and get caught up one recording at a time. Subscribe now at convome.com/read to me, and you'll get immediate access to the entire library of audio recordings not available on the free convome.com site or anywhere else. Then stick around because I add new audio content to the library continuously. If you like what you hear in this episode and in this podcast in general, go to convome.com/read to me to subscribe to Etsy Success Strategies, the audio series.
Welcome to the Etsy Conversations podcast, featuring inspiring interviews with Etsy shop owners, hosted by Ijama Elazu.
Hello, and thank you for joining me for another episode of the Etsy Conversations podcast. I'm your host, Ijama, and I am glad to finally be recording this episode. As many of you who listen to the podcast know, I put a call out for any questions that you had for a lawyer regarding copyright and trademark issues. And so I got lots of questions back. Thank you to everyone who submitted your questions. I've put them all together, and I finally do have my lawyer on the podcast as my guest. His name is Jared Haney. Jared is with the Cambridge law firm in Colorado, and I'm thrilled to have him on the podcast. I've worked with him. He's helped me tremendously, and I knew that he would be just the right person to come on the podcast and respond to your questions. So Jared, thank you so much for being my guest, and welcome to the podcast.
Thank you, Ijama. It's great to be on. You're very kind, and it's a pleasure to be here. I think your podcast is a terrific thing, and I'm excited to be here and try to answer some of these questions today.
Great. Thank you so much. So before we start, can you just tell us a little bit about yourself?
Well, I am a lawyer. I practice here in Denver. My partner and I, my business partner, we operate a small practice that is focused on general business law, meaning that we help companies, mostly small to medium-sized companies, with all different kinds of business needs, including, as we're going to focus on today, issues that touch on trademark and copyright law.
Yes. And for anyone listening, if you're selling on Etsy and you plan to make it a business, like a real business that is generating income, or if you already are generating income and you haven't quite gone through the process of setting up your business correctly, I would really encourage you to reach out to a lawyer or someone who can help you get your business set up. And that's one of the things that I had the privilege of doing with Jared, was just getting all my ducks in a row, making sure that my business was set up correctly, having all the proper paperwork filed when they should be and filed with whom they needed to be filed, and everything down to even setting up my business bank accounts. Jared was able to help me. He laid out everything for me that I needed to do, so I wasn't missing any steps. And he helped me with the things that I wasn't fully confident in doing myself. And so if you haven't yet had a chance to do that with your business, and you really want to run a serious business, then I encourage you to find a lawyer or someone who specializes in setting up businesses to help you get your ducks in a row. Now, Jared, is this something that only lawyers do, or are there other people, like, say, can an accountant do that for someone who's listening that realizes they need to get set up properly?
Accountants can be great resources, and certainly every business, small or large, should have an accountant that they can go to and ask these questions to. Accountants and sometimes the line can get a little blurred between what the accountant is expert at and what the lawyer is expert at, but generally the lawyer is there to help make sure that your business is set up correctly from a legal perspective, and to make sure that you as the business owner are protected legally and have that liability shield in place in case there should ever arise lawsuits or other things that the business will need to respond to from a legal perspective. But accountants absolutely know their sphere, and they know a lot more than lawyers do in terms of dealing with the IRS, or unless you have a tax lawyer that has that specialty. That's not my specialty, but we do help businesses get on their feet and get organized in the proper way and make sure everything's done so that those protections are in place.
Okay. And so it's just good practice, I guess, to have a lawyer and an accountant just to make sure all our bases are covered.
Absolutely. I would absolutely recommend every time that you visit with both an accountant and a lawyer, hopefully, both, to make sure. Now, sometimes people say, well, that's a lot of upfront cost.
Yeah.
And it does cost money. There's no question. And so I wouldn't necessarily recommend it before you ever sold one widget. Okay. But if you already have the idea in motion and you've started to make some money, if you're just starting out, I'm talking about very small businesses here. Mm-hmm. If you're only going to make $5,000 in a year, I wouldn't recommend spending all of that on your lawyer and your accountant necessarily. But if you're going to grow and create something that's going to create a livelihood for yourself and your family, it's definitely worthwhile to make sure that everything's done right, so that down the road you don't have any surprises that could cost you a lot more than the relatively modest sum that it might cost to get things set up right in the first place.
Okay. How long do you think is a safe period of time to go before setting up your business structure? So like with a lot of Etsy sellers, we start off as hobbyists or on a very small scale. If it's not a hobby, it's not out of the gate making thousands of dollars. So how long do you think is safe to go before one switches from just selling as me or doing business as myself to setting up a business entity? And should that be measured in time or in dollars earned?
Well, those are great questions, and it's really a balance that every person has to decide for themselves in terms of the risk that is happening. Let's say that someone is selling consumable products, some kind of food-based product. Those products could potentially get someone very ill if there was something went wrong. And when you're first starting out and you're just giving them maybe to friends and family or neighbors or coworkers, you may think, well, the risk is small, and it probably is very small that something like that would happen. But as you grow, you start to develop relationships with people who are just coming to you only for your product that you are carrying, and you don't really know them other than, in some cases, you may not know them at all if this is being done online. Mm-hmm. And so that's where the risk starts to increase. And again, it's very, very case specific, so that some things that you sell may carry very little risk of liability because there's not really much inherent danger or damage that could happen.
Yeah.
Other things may have a significant risk. If you're selling little toys for toddlers and your little connection breaks off and the toddler chokes and dies, well, that's a huge risk. And obviously no one wants that to happen in the first place. But you've got to think about the kinds of things that you're selling and how much risk you're going to incur. I don't think there's anything wrong with, in fact, I commend those businesses that kind of start organically out of someone's backyard or in the basement or, whatever it is, where it kind of starts, as you say, as a hobby.
Yeah.
Then it grows into something more. And then, potentially it turns into a full-time situation that supports the family. Those are terrific. And you have to gauge when inside it, you're feeling like, okay, this is now more than just selling to friends and family and coworkers. Now this is a business where people are expecting me to provide a product. And if it goes south for whatever reason, and there's no relationship there other than they bought a product from you, that's where the risk of lawsuits really increases. And again, it depends on your product. So I can't really say there's any hard and fast line where I would say, well, you can't make more than this much money or wait more than this much time.
Okay.
We've all done things where you have a garage sale, for example, or you just kind of sell things as a one-time thing or even as a small hobby. You're probably not in any huge danger, although from a tax perspective, every dollar you make, the IRS wants an accounting for, whether it's as a hobby or as a full-fledged business. So the IRS is not going to make any distinction as far as that goes. But from a legal perspective, you've just got to weigh those risks and decide when the time's right to form a business entity, to get insurance, to set up a bank account, and all of those other things.
Okay. Now, when you say the IRS wants an accounting, you mean they want you to pay tax on every dollar you earn?
That's right. So
okay.
the income code, again, I'm a generalist. I'm not a tax accountant, but I do know enough to know that the IRS expects the taxable income for individuals is based on every dollar of income, however earned.
Okay.
So it doesn't matter if it's from a garage sale or anything else. Now, most of us don't go through and take the time to do all that.
Yeah.
But certainly if you have a little hobby that's bringing in a small, even if it's a small regular income, you ought to be making sure that that's accounted for so that you don't get penalized and so forth.
Okay. Now, I know we talked about that once before, and that took me by surprise when you said essentially the IRS wants you to pay tax on every dollar earned, because I know there's this theory that's swirling around in the small business community that something about you don't have to pay tax until you earn $600 or something like that. And I don't know if I mentioned that to you, but I heard that somewhere in some selling circles that I've been around. And so I thought that was the law until you told me, no, every dollar you earn, they want their taxes on.
Yeah, that's right. Now, it may be, there may be some exception that I'm not aware of. Again, I'm not a tax attorney, so, but I do know the general rule is, and when I say every dollar, you're also allowed, of course, to take into account your expenses. So if you have a little hobby and you spent $50 on materials and you sold your end product for $60, well, then the difference is you made $10, and that's what you need to pay your tax on. So, an accountant could tell you all the other ins and outs, but the bottom line is, where we started on this kind of, the thrust of this conversation was, when do we stop treating this as just a hobby and start treating it as a business?
Yeah.
And those are difficult choices, but on the accounting side, I just wanted to make clear that there's not really an option to just say, oh, this was just a hobby. Well, even if it's a hobby, the IRS wants you to say, okay, if you made $1,000 and spent $1,000, great. But the IRS wants to know that you made $1,000 and spent $1,000. In that case, you wouldn't owe any taxes. But and again, I'm speaking in generalities. Your accountant would to steer you toward all the specifics. But the bottom line is folks need to just be aware of these issues. And sometimes I know what happens, partly from my own experience and other from my clients, is before someone knows it, that their little hobby has turned into something that's bringing in quite a bit of revenue. And it's not that they intended it to be that way. It's just they got busy and they were involved with all kinds of different things. And next thing you know, they say, oh, well, I guess I better form a business. So I know that happens, but it's just something to be aware of.
Yeah, and actually that's really the typical genesis of most Etsy businesses. Is it's a hobby, someone is sharing or giving away what they make to friends and family until they get tired of receiving them and convince them to start selling online, and then the hobby becomes a business. But before we leave this topic, I just wanted to say one last thing. And I know I did an episode on this. The fees, the costs that one would pay to consult with a lawyer or an accountant is tax deductible under certain categories by the IRS. So if someone who wants to go ahead and make their Etsy hobby now a business, and they did decide to consult with a lawyer or an accountant, the amount that they spend consulting with those professionals can be deducted from their taxes. Or am I saying that right?
Yes. No, I mean, again, I'll leave all the details to the accountants, but they are business expenses. There's no question about it. And they would be deductible. The one point I wanted to add on that is that, at least from my perspective, I think some of these fees are even less than you might expect. I know before I went to law school, I never knew any attorneys. I had no interaction with attorneys. And I thought that it was a world of that you couldn't even touch because it was so expensive. It was just for the super rich.
Yeah.
And that sort of thing. And now that I'm in and I live in this world now and I work in this world, I see that, we keep our fees at a place where I think just about every small business that was successful in any stretch of that word could afford the fees that we charge to get set up and get going and to cross their do all the things that a business needs to do to get set up right. And I think the same is true in my experience for accountants.
Yeah.
I think they generally, the fees that are charged are quite reasonable in terms of the expertise that you get, instead of trying to purchase some kind of software and try and figure it all out by yourself.
Yeah, and I did that, and you're right. I was very intimidated before I reached out to you for help, just with setting things up, because I thought consulting with a lawyer was going to be outside of what I could afford to do. Like you said, I thought it's really just the rich people who can afford to consult with lawyers and whatnot. But I think it has been worth every penny I've paid. I feel so much more comfortable with what I'm doing and how everything is set up.
Thank you. And I hope that's our goal here. My business partner and I, we both came from pretty modest circumstances, and we like to help regular folks with regular problems, and that's kind of what we do over here.
Okay. And so if you want to check out the website, it's cambridgelawcolorado.com, and Jared's with Cambridge Law in Denver. Okay, now we can go on to your questions. I'm sorry that the conversation went in that direction, but it just seemed relevant to talk about all that because I know other people have similar questions. So now, some of these questions were submitted anonymously. And so if someone chose not to have their name mentioned or their shop mentioned, I won't mention their name or their shop, but I'll go ahead and ask the questions. So, Jared, before we get into that, though, do you want to give your lawyerly disclaimer?
Ha. Yes. So a lot of these questions are very specific, and I'm happy to discuss my thoughts on them and to give you a little bit of maybe a lawyer's 2 cents on what the issues might be and what the law might have to say on these things. It's important from a legal standpoint, though, that all of your listeners understand that in answering these questions, and even in the discussion that we just had about setting up a business, this is not, I'm not giving out what's technically understood as legal advice. In other words, no one listening is my client, and I'm not their lawyer. This is just a lawyer giving some thoughts on some questions. And so there's no attorney-client relationship here. And I certainly will be the first to say that I do not know all the facts and circumstances that are behind each one of these questions. And as you also may appreciate, having discussed with me some of the issues we've discussed, Ijama, I think people don't understand how fact-specific these things can be, and how the law really does the facts matter. And so when you have a one-line or a one-paragraph question, it's very difficult, and I'm not even trying to do that, but even if I were trying to give a definitive answer on these things, it would be almost impossible to do that with such limited facts.
Yes, I agree. Without knowing the whole picture, it's hard to give the full answer. So thank you for the disclaimer. But I think I'm just grateful that you're going to share your knowledge with us, because I know, especially within the community of Etsy, we try to help each other, and many of us aren't lawyers, and so we're interpreting things that we think are right. And I think most people come from a good place when they try to do and they try to do the right thing when selling or running their businesses. So I'm just grateful that we can talk to someone who actually does know the law, and so we're not all just guessing amongst ourselves.
Well, that's great. I'm looking forward to it.
Okay, good. So question number 1 comes from Eliska C. When is using a phrase or something similar considered fair use? For example, is it okay to use a copyrighted phrase on a piece of artwork?
Okay, so this is a great place to dive right in. It's interesting. A lot of these questions that I think we're going to talk about today are one of the things that's inherent in the question is there's no bright lines. So let me step back and just educate the listeners just a little bit about how the law works. Okay. And that, I think, will help them understand what the answer is to this question.
Okay.
The law, there are laws that are on the books, and the laws that are on the books generally are called statutes, and they control to a great extent this world of copyright and trademark. The issue is that the laws that are on the books are of necessity written very generally. For instance, there's no law on the books that says you cannot copyright a Disney cartoon character. That's not a law. What the law says is that copyrighted and trademarked works are protected, and then it goes into all the details. And then if a dispute arises, if you were to try to incorporate some kind of copyrighted or trademarked expression, which is the question here, the law then would be presented to a judge, and there would be a dispute. One side might say, no, we're allowed to do this. The other side, who owns the expression that's being used or claims to own it, would object, and the issue would be put to a court, and the court would ultimately decide that very specific question based on all the facts and circumstances of that case. So I think most people who are not lawyers tend to think that there are easy, clear-cut answers to questions. All you have to do is posit the question, and there's an answer somewhere in a book somewhere.
Mm-hmm.
And that's just not how it works. So with that preface, the question is, when is using a phrase considered fair use? And then specifically, is it okay to use a copyrighted phrase on a piece of artwork? So this is getting, again, pretty deep for the first question, but it's a good place to start. So fair use is brought right up. It's kind of a term that it's a legal term of art, meaning it has a very specific meaning, but it's one of those legal terms of art, almost like the Miranda warning. You have the right to remain silent. Everyone knows about it, even if you're not a lawyer.
Yeah.
Right?
Uh-huh.
People have heard about this. Fair use. So fair use is an exception to what would otherwise be protectable copyrighted material. There's also a trademark fair use, but this is the question here is based in the copyright question. Fair use, I think, is not what people think it means in the lay public. A lot of people think fair use means, well, if I use it and it's on my own product and I somehow incorporate it, well, that becomes magically it's fair use, because I'm not. It's not. It's not the very same thing, and of course, it's not the very same thing because you're not just turning around and using something that has not been altered or changed in any way. But fair use isn't quite that simple. I don't want to bore your listeners here with too much legal mumbo jumbo, but there's 4 factors that go into a fair use analysis, and I think most courts would say that the most important factor is probably the first factor, although all of them come into play, so you can't ignore any of them. But that first factor is looks at the purpose and character of the new use that's being used. Uh-huh. And whether that use is what's called transformative, and we'll come back to that issue in a minute. But the basic idea is to give the short answer, which is too late for that, I know. But to give the short answer to this question is, it's probably almost never okay to use a copyrighted phrase on your artwork.
Wow.
If you're just going to use it in a to convey the same idea that the copyrighted phrase conveys. Now, I don't know what this person is seeking to do or trying to do, but for instance, if probably one of the most famous copyrighted phrases would be, and it, there's some trademarks in it as well, but "just do it" would be a copyrighted phrase.
Okay.
If I can use that phrase. I mean, it's not illegal to say those 3 words together. But if I'm going to portray athletes in action with "just do it" on my artwork, probably not going to fly, right? So if you transform it, remember the transformative is a big factor. If you're using it in a way that's completely different from what its copyrighted intent was, mm-hmm. So Nike uses that phrase and uses it in the context essentially of athletic sport competition. If you were to use that phrase in some other completely unrelated field, farm products or something, it might be a closer question. But it's hard to answer it sounds to me like it is being used in a way that mimics its original intent and purpose. And
Well,
so
okay,
I
sorry.
don't know.
I don't mean to cut you off. Go on.
No, it's hard to, without, again, we mentioned this at the beginning, without all the facts and understanding, it's hard to know where the question is going or coming from. So I don't know really where else to.
Okay, so let me give you an example of what I think she might be referring to.
Okay.
If I were to make a print, an art print, maybe I paint it or I make it using digital art, and I make it all flowery and look very pretty, and I write or paint, just do it. Something that you can frame and hang on the wall. Is that okay?
That you say you make it flowery. Are you trying to say that it's not related to athletics at all? Is that what you mean?
Yes. So I'm just using the phrase, and I'm just isolating the phrase and making artwork out of it that someone might want to hang on the wall for inspiration, not necessarily for, like, they might want to hang it on their office wall just, to be inspired to work, or in their crafting room to be inspired to create.
Right. Well, I'm the one that threw out that example. It's probably a poor example because it crosses into trademark as well. That's a trademark expression, I'm almost sure, which trademarks have different rules that apply, and they apply even to outside. If it's a famous trademark, they get even extra protection. But in general, I mean, a copyrighted phrase could be anything. It could be lyrics from a song. It could be a famous quote. It could be, almost anything that is committed to paper could be a copyrighted expression, or even audio, right? If Paul Harvey, the rest of the story, you have all these famous, or not, it doesn't have to be famous, but those are the ones you think of when you're trying to think of examples. So, it's just a fine line, and it really depends on the facts. To the extent you're using a phrase, what I tell clients when I meet with them is you have to think about the reason that you're wanting to use this particular phrase, because the idea of just getting in there, for instance, going back to the just do it, if the idea you want to convey is, get in there and get the job done, you have to ask yourself, maybe, why are you going back to a phrase that's copyrighted? Because ideas are not subject to copyright protection. No one can have a monopoly on the idea of getting a job done, or the idea of performing at an excellent level, or those kinds of ideas, or any other idea, is not subject to protection. So you're always free to come up with a phrase that conveys the same idea in a different so many different words or ways. And so I always, when I'm talking with people about copyright, I always ask them, well, why is it that you want this particular phrase? And if the reason is, well, I really like the way it sounds, or people know this phrase, or then that's kind of a red flag. It should be in your own mind, because what you're really saying is, I could express it differently, but I like the way this guy expressed it, or this gal expressed it. And so that's where it gets onto dicey ground as to whether or not the copying is really fair use, or is it just copying?
Okay.
So I would say, that's not a legal test. Why are you using it? But it's something to ask yourself, and I think it answers a lot of questions when it comes to whether or not something is permissible. If the reason you're using a phrase or a motto or a saying is because it's famous, then at that point, you've got to really do a more careful analysis on fair use or on some other defense that may allow you to use it. But going back to where I started, the fair use defense is not nearly as broad as people, I think, in the public think it is. I think people in the public think that fair use is as wide as the Grand Canyon, but it's really a pretty narrow application that allows certain things to be done, but really requires some originality or creativity to make it probably in most cases a different thing than it was used for in the first place.
Okay. I know we've talked about fair use, and I'm one of those people who thought, well, it's fair use if I do X, Y, and Z, and, got educated about what fair use really is. And like you said, there's a misconception about what it covers and what you can and can't do under that.
Right. Let me just read. This may help people understand a little bit about fair use. This is the statute. It's just one line here. And so it says, fair use is allowed, and then here's the quote, for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. So those, you notice fair use, one of the categories is not for profit or something, I'm taking this and using it for my own.
Yeah.
Unless you are commenting or criticizing, it's very difficult. Now, the other thing that people don't understand is that, again, going back to this idea versus the expression of the idea itself is not copyrightable.
Mm-hmm.
It's how that idea has been expressed. And this goes back to our grade school days or middle school or high school, whenever it is, when your teachers start saying, well, look, when you quote someone, you got to put it in quotes and give credit where credit is due.
Mm-hmm.
And so that certainly is allowed, limited quotations, but you can't go take a whole book and put it in quotes and put a new title on it, right? No one would think that was okay.
Yeah.
So all of this creates balancing and thought, and it depends. Again, we don't really know very much on what phrase is at issue, what kind of artwork, how's it being used. Is it a criticism? If it's used for criticism, and the only way to criticize it is to use those words, I know years ago, this isn't a copyright issue, but read my lips was something that one of our presidents said, right?
Mm-hmm.
Read my lips, no new taxes, and then I think the taxes are raised or something. So that became widespread criticism. Now, those words were used and repeated. Now, again, those aren't copyrighted, but to give you a sense of famous phrases that then can be used to show a parody or to show some kind of criticism or commentary, the courts are going to be open to that sort of thing much more than if you just say, well, I really like how it sounded.
Right. Okay.
So,
along those lines, regarding using phrases or from text or that are out there to create something for profit, are phrases from religious materials copyrighted? So if somebody wants to make artwork using a Bible verse or something of that nature, is that
the copyrighted, the Bible, it's an interesting question. I've never done research on the Bible specifically.
Okay.
there are some things that are in the public realm
Uh-huh.
that are not that are viewed as being part of, no one has ownership of them. I don't know if the Bible is, I'd have to do some research. I would assume that the Bible is in that category and that there's no issue. Now, that being said, there are many versions of the Bible, and if someone comes up with their own version of the Bible and copyrights it, that could be subject to protection. But some of these versions of the Bible go back hundreds and hundreds of years. The version of the Bible that we read in our family is the King James Version.
Okay.
And so that was, I think, 1611 or something like that.
So it's safe.
Yeah, I doubt there's any copyright issues there.
Okay.
But some of these newer versions of the Bible, it creates an interesting question. If someone came out in 2017 with a new translation, you may certainly translations are protectable, just like other things. But I wouldn't worry too much about quoting scripture.
Okay.
I wouldn't try to take credit for it. I would say if this came from the Book of Psalms, I would give credit for it and not make it sound like you were a poet yourself.
Okay. All right. Okay. So question 2. And I think you already kind of touched on this, but I'll just read it anyway. I see song lyrics all the time on so many products. How is this not a violation of copyright?
Good. So this touches on something we already mentioned. Song lyrics are absolutely protectable as copyright material.
Okay.
And the answer is it probably is a violation of the copyright. Just because that's one thing. It's almost like teaching your kids. You say your son or your daughter says, well, so and so did it, and you say, well, just because so and so did it doesn't make it right. Mm-hmm. So just because you see things happening in the public and in the marketplace doesn't mean that whoever's product that is not infringing on some kind of copyright or trademark protection. It also doesn't mean that they are infringing, because it's possible that they have permission. You can always get permission if they'll grant you, a license or some kind of royalty rights.
Yeah.
That they'll share with you or that you'll share with them for that use. And depending on who you're talking with, certainly the bigger the players, the less likely it is that they're going to, from a practical point of view, that they're going to reach out to you and say, yeah, you can, if I'm a Denver Broncos fan, they're probably not going to license me if I'm just selling T-shirts on the internet. Maybe they would. I don't know. But it seems less likely that they do that, and they want more control, and they don't want little guys out there that they have to keep track of. So I would say just because you see something, and in this case they're talking about song lyrics. Yeah. Song lyrics are absolutely protectable, and you shouldn't be using them unless you have the writer's permission, or the copyright holder, which is not always the writer.
Okay. So along those lines, this wasn't in the question, but I just thought of this. So song lyrics are copyright protected. Does that protection only apply to the entire song? What if there's a string of words I want to use, which maybe in everyday life I would say anyway? Is that a blurry line if I take, just a line or, a part of a line that are words strung together in the song that is protected?
That's a great question. And again, it gets into, this is where people talk to a lawyer and they say, man, there's no clear answers. And it would absolutely depend on how unique that phrase was. If it was something that was common to everyday speech, then it was just a few words that were strung together in as part of a song, that doesn't give the copyright holder of that song any magic monopoly over that expression. And a lot of times songs do have expressions that are just everyday language. But again, you have to go back to the question of why do you want that expression? I think again, it's a good rule of thumb to check your bearings. If it's because the song made that expression popular and that's where you're going, that's different from, oh, this is already an expression that just happens to be in this song. So I would say just be prudent on that. Certainly common everyday expressions. Home is where the heart is a subject of a number of songs, probably old country, sappy songs and other things. But that's just a expression in the English language that I think anyone could use.
Okay.
Home is where the heart is. I don't think anyone could obtain a copyright on that.
Okay.
On that phrase or other phrases like that, 1,000 other phrases like that.
Okay. Okay. So moving away from words, question 3 is it copyright infringement to use a copyrighted photo as a reference for a painting? I'm not selling their work, but rather my own original artwork.
Good. So this has a couple of layers in this question. The first issue is seems to be asking whether, actually it implies that photos can be copyrighted, and that is correct. Photos absolutely can be copyrighted and are copyrighted, and that's one thing. This I know is not directly on point to this question, but it's probably something that a lot of your listeners run into. If you're going to put photos on a website that you run, or if you're going to put them on some of your products or marketing materials, you absolutely ought to and should, to comply with the law, either take the photos yourself, or if that's not practical, and a lot of times it's not, go and purchase those photos from a photo stock company. And there's a lot of them out there that have tens of thousands of photos to choose from, and they're really good photos and they're high quality, and for a couple of bucks or $10 or whatever it is, you can buy a photo and put it on your website legally.
Okay.
So I would say that's one thing that a lot of people I think are getting more educated about in today's world, that every photo, just because it's on the internet, doesn't mean you can take it. And use it. So I think most of your listeners probably understand that idea, but that's good to make clear. And every photo, if I take that photo and I post it, it's my photo, and no one else can use it unless I give them permission. And that's basically how it works. That's a layman's version of how the law is regarding these photographs. And there's exceptions where maybe, someone pays you to take the photo. Well, then maybe the person who purchases the photo has it, and maybe the person who takes the photo keeps a copyright interest as well. Maybe they both do. That's subject to negotiation, but certainly the person who had no dealings with the transaction can be sure that they have no rights to the photo. Or drawings. This comes up with drawings too. You see a little cartoon character or other things, those are also copyrighted. So the question is, if you use what is admitted to be a copyrighted photo, and then it says as reference for a painting. I think that's maybe to get the idea across that they're selling artwork, and they're going to use a famous painting to attract someone's eye. That would be a violation. I can't speak definitively on very many of these questions, but this would be a violation because you're using that person's photograph, or in this case, yeah, it's a photo, not a painting.
Yeah.
But you're using that photo without permission, it sounds like, for your own profitability. So that's not going to be a fair use. That's not any commentary or criticism or anything original. You're just using it to direct traffic to you, and that's going to be prohibited. So I would say choose a different photograph. Go online with these stock companies. If you know who owns a photo, contact the person for $100, or I don't know how famous this photo is. If it's not famous, they may be more than happy to let you use it for free or for a small fee. But yeah, to comply with the law, that's going to need to be addressed. And just because you're not using it, you're not purporting to sell that photograph, you are using it to promote your own business, which is not allowed.
Wow. Okay. That answer shocks me. I thought that would be okay.
You thought that would be okay?
I did.
Yeah. And I can see why, it's particularly in this age where you just do a search and 10,000 images come up, and you can see different paintings and different photographs, and you say you like this one or that one. But the safe bet and the safe road is to go down to the stock photo store and get something that works for you, or reach out and get that person's permission.
Oh, okay. Good to know. And then along those lines, is it true that anything the U.S. government puts out, whether text or pictures, is all public domain? So if anyone wants to use any U.S. government produced materials in their own product or what have you, there is no copyright protection?
I've heard this spread about as well, and that it's not as clear as you might hear it in some places where you've heard this repeated.
Okay.
Certainly it's true as to public records. For instance, there's no copyright in the Declaration of Independence. You can quote that as long as you want. You can put the whole thing up on your website, and there's not going to be any violation. But sometimes the government actually is involved in other areas that are not matters of public record, and those areas could be subject to copyright and trademark protection. Probably not so much trademark protection, but more and more you see this line getting blurred in a number of different ways. If you remember the big financial bailout in was it 2008 or 2009, and the government bought into and basically took over large portions of GM and Chrysler and other auto companies. So where it's not clear exactly from a trademark and copyright protection that just because the government became an owner in those that trademarks and copyrights were affected in any way by that action. So if people are going to quote statutes or quote other public records, meeting minutes and other things, that's pretty safe. But once you get beyond those public records, you really ought to talk to a lawyer and see what the question is and what the issue is.
Oh, okay. Again, surprised by that answer, because I thought everything was fair game from the U.S. government.
Yeah, the lines are not as clear as you might think. So I would say certainly the public records, you're safe there.
Okay.
Once you get on those, it's worth a phone call to your lawyer to make sure that what you're doing is okay.
Okay. Okay, so The next couple of questions come from Stacy H, and she runs the Etsy shop Original Sock Dogs. And I'll give some background. So some of these questions have an explanation just so that you understand what they're asking. And so Stacy used to work at Disney, and so she is familiar with the artists at Disney and the work they create. And so her first question is, essentially, why do you think Etsy doesn't enforce another organization's copyrights rights on their platform?
Well, I'd just be speculating to in terms of what Etsy's internal policies are, but from a big picture, companies like Etsy that host content that Etsy doesn't put up, you can understand, it's not difficult to understand why a company like that would not like to be in the business of vetting every single word that goes through. It would be a practical impossibility. I think Stacy's concern is that some of the products appear to be blatantly, you wouldn't need a fine-tooth comb to figure out that there was some infringement going on.
Mm-hmm.
And that may be the case. I don't know. I haven't been on these sites personally, but I would say oftentimes it's not as clear cut as you might think, and you never do know if someone has an agreement with the copyright holder. That's why it's always dangerous to look around and say, well, I see this being done and that being done, therefore it must be okay. Well, maybe, or maybe not. Maybe they just haven't, in this case, maybe there's not a police on this particular server or platform that are going around and trying to enforce these things. But more than that, you never do know who has reached out and made a deal. That's all a matter of negotiation, and it could happen in theory, it could happen between any two parties anytime. So, from a practical perspective, I don't think it's difficult to see why a company like Etsy is just going to say, well, it's up to copyright holders to police their own copyrights. And I'm not saying that is their policy.
Right. Yeah.
It is, but if that is their policy, it certainly has some practical sense to it.
So would it be up to the artist who say they do have a license or royalty, some type of royalty agreement with a copyright holder, to put that in their listings? Does an artist or someone who's making a product using someone else's copyrighted material, are they obligated to make that information public?
That depends on their agreement between them. That it's certainly in the absence of any other agreement, I think it's a good idea to say used by permission or something similar like that, so that, because otherwise you risk being wrongly and falsely labeled an infringer by your customers or by other people in the marketplace. And so I think if it were me, I would want to let people know that we're doing things the right way and that we have permission if there's something that would otherwise look like a blatant violation.
Okay.
And so I think there's some good reason to do it, but that would be a matter of negotiation between the two in terms of the legal obligation to do that.
Okay. All right. Okay. Now, Stacy's second question has to do with the disclaimers that some sellers put in their listings. And she says, does making up / including some kind of disclaimer statement make it okay to use copyrighted materials or characters in your own creations without a license or the owner's permission?
So there's nothing, if I'm going to use, let's say, going back to that painting idea, I'm going to put a famous painting or a famous photograph on my website, putting a disclaimer on there that says, this is not my photo, or I'm not selling their property or their products, really makes no difference in the copyright world. The bottom line is you need permission from the copyright holder, unless you have some of these other things at play that we've talked about, whether it's fair use, or which again is a fairly limited place that you can go in terms of trying to defend yourself. But you might be able to say the idea versus dichotomy, the idea versus expression dichotomy. I think on the whole, disclaimers, it's kind of like putting a Band-Aid on something that needs a lot more than that. So it's a good attempt, and certainly I can understand why someone might be thinking, well, it's a good try, but it's really not going to the heart of it, which is you just really need to get that person's permission if you're going to use this copyrighted material.
Okay. You don't have very much good news for us so far, do you?
Well, what I tell people when we get to, because at some point people say, well, I can't use this, I can't use that. And you say, well, sometimes the things that people want to use have become successful because of the efforts that were made to make them successful, that other people went to those efforts.
Yeah.
And so my response always is, look, you have great ideas yourself, and you have a great amount of creativity in your own mind. And the challenge is to use that creativity to develop something that is successful on your own, that doesn't need to, ride on the shoulders of someone else's work, which is really what the copyright and the trademark, in a broad sense, is designed to prohibit.
Okay. Okay, so the next question is from an anonymous seller. What is the difference between copyrighted material, licensed products, intellectual property, and trademarks? Okay,
good. So intellectual property covers all a broad tent, and what it means is that you can actually own or have an interest in, is what the law would say, intangible things or almost intangible things, such as a photograph. We often don't think of those as being our property, but they are property. Not only the photograph itself, but its reproduction, its dissemination, its publication, and so forth. So it's called property in the sense that someone actually owns it and can enforce those rights in court if need be. So intellectual property covers, among other things, it covers copyrights and trademarks. The first question she asked here is, what is copyrighted material?
Yes.
Copyrights extend to all original works of authorship fixed in any kind of tangible medium, whether it's, we've talked about them here, audio, video, paper, paintings, pictures. So those are all, if it's an original, if I go out tonight and take a picture of the sunset, that's original. No one else has ever taken it from the spot I was standing in at the time I was taking it, and so on and so forth. It's an original work. And so I would own a copyright interest in that photograph.
Even without filing an official copyright thing.
Yes.
Okay.
Yeah, so I'm glad you brought that up. That's another kind of a misnomer that some folks have is they say, well, I found this photograph or I found this poem or whatever it is that they want to use, and they say, well, it didn't have any indication that it was copyrighted or that it was protected or that it was designed by so-and-so or anything else. That doesn't matter. You can and take the extra step, and it provides some, I won't get into all of it here, you really will put all your readers to sleep, your listeners. But it can provide some extra protection to you if you do go and get something copyrighted as at the federal office. By the way, copyrights are mentioned in the federal Constitution, trademarks and copyrights. So that's kind of interesting. But you don't have to go do that. And as a practical matter, 99.9% of all copyrighted material in this country is not officially copyrighted. If you go down, if you create a website, websites are a good example because they're constantly changing. Every day, if you're a news website, you got new news stories. If you're a sports website, you've got new updates about the game from last weekend or whatever it is. And even if you're just a business website, you're constantly creating new products and new pricing and new blogs and all these things. All of that is copyright protected by the owner of the website and whoever created that website. So even though, as a practical matter, no one is going to take the time to create a new web page and then go register that web page. I mean, for certain materials, this would happen, I'm sure, high-end things, but for run-of-the-mill websites, that's never going to happen. No one's going to take the time to go file a filing and get it protected, because by the time all that gets done, the website's going to be obsolete and they're going to be on to the next thing.
Yes.
So that, I think, helps people understand that, okay, I get it. So a website is protectable. It's an original expression of an idea. And it's absolutely protected. And I think there's a couple of questions that deal with websites. We can talk about those more specifically. But people should absolutely know and understand that it doesn't have to have a little C with a circle around it. It doesn't have to have anything to be protected. It just is protected. And the person who, for instance, took that sunset photograph tonight, whoever took the photograph, that's theirs. Now, there's some wrinkles, if I took it for hire, if someone paid me to do it, maybe the person that paid me owns it and so on. But if you didn't take the photo and you didn't pay anyone to take the photo, you can be sure that it's not yours.
Wow.
So 2 other things here that she asks. So that's copyright. Any questions do you have questions about what a copyright entails?
So
does that make sense?
Yeah, it does. But does copyright, can only physical, tangible products be copyrighted?
Well, it has to be in a tangible medium. So this podcast is copyrighted, even though it's hard to say it's tangible. It'll be on the website, but it's hard to pick it up in your hand and walk around with it. But yeah, it has to have some kind of tangible expression. You and I having a chat over lunch, the words that you use or the words that I use are not copyrighted.
Okay.
Unless they're recorded, like right now, and this podcast are being recorded and put on your website. But if we just have a conversation, then it's not. But if you took a canvas and you put splotches all over it, that's your artwork. It's copyrighted.
Okay.
Now, it has to have some originality to it. That, I don't know, that may not happen, but as long as there's some originality to it, it's going to be protected.
Okay. Okay, when you finish the other definitions, I have another question similar to that, but I want you to finish the definitions.
Okay, great. So let's move on then. Let's skip over to trademark. So copyright is original works of authorship that are in a tangible medium, recorded, writing, paper, however it is, audio, video, all of that's copyright protected. Trademarks are different, and people sometimes get these mixed up. Trademarks are used to help consumers quickly identify businesses and their products. So a trademark is different from a copyright in that it's directly tied to consumers, businesses, and products or services. They call them service marks if there's a service company, but we'll just call them trademarks for purposes of this show. So a trademark, almost all business names are trademarked. Almost all famous business products are trademarked. So 7-Eleven, the service station is I cannot go and start a new business called 7-Eleven that does a service station. 7-Eleven would bring a trademark infringement case against me if I did that, and they would win. So same thing with the products that 7-Eleven carries. 7-Eleven carries, for instance, when I was a kid, we used to go down there and get Big Gulps in the summertime and Slurpees, right?
Yeah.
And those products have also been copyrighted. So I couldn't open up Jared's service station and sell what are called Slurpees. I could sell ice drinks with flavor in them, but I couldn't call them Slurpees. That 7-Eleven has staked out that term, and it belongs to them. Same, I think Big Gulp is also trademarked.
Huh, okay.
So I couldn't open up my own service station and sell Big Gulps with soda. So I could sell soda, but I couldn't call them Big Gulps. That's what 7-Eleven sells. So that's what trademarks are used for. They're used to quickly identify businesses and their products, and that's the difference between trademarks and copyrights. Unlike copyrights, most trademarks, if they have any degree of success at all, are registered with the trademark office. They don't necessarily have to be if they've been in use, but most trademarks do get registered and are available to search in a database. It doesn't mean that you're automatically protected if they're not there, but that's a good place to start.
I have a question, before you move on. With regard to the trademark, so like say with your example with the 7-Eleven, you said you can't open a similar business, so like another service station type of business and call it 7-Eleven. Well, what if you do artwork and you want to call it 7-Eleven Designs because maybe your street address is 7-Eleven X Street?
Mm-hmm.
Is that infringing on the other 7-Eleven's trademark?
That's another terrific question. I'm glad you asked it. The answer is usually if you have a distinct service, you're going to be on much stronger ground. For instance, in your case, and you also had a reason for calling it 7-Eleven, right? Mm-hmm. It's your address or something.
Right.
All those factors come into play. The courts have developed, and I think now it's actually codified into the statute, something that protects famous trademarks, even if it's unrelated. So, for instance, going back to some famous trademarks, like take Nike, one of the most famous trademarks, or Coca-Cola, right? These are hugely famous trademarks around the whole world. Mm-hmm. Coca-Cola, because it's famous, even if I was going to sell Coca-Cola automobiles, Coca-Cola could come and say, now hold on, you are diluting our trademark by everyone knows that a Coke is a soft drink. And now you're going to cause confusion. People are going to say, really? Coca-Cola automobiles? Is Coke getting into the auto business? So that only applies to very famous trademarks, but sometimes that's what people want to mimic. If it has nothing to do with it and it's not a famous trademark, then the trademark only extends to those products and services that the company sells.
Okay.
So if there's it's hard to talk in terms that are not famous because the only ones that people know about across your audience are all going to be famous.
Famous ones, yeah.
If there were, let's say, Super Duper Pizza, and that, let's say that was a trademark that was copyrighted, Super Duper Pizza. Well, if I wanted to do Super Duper bouncing balls, Super Duper Pizza is not going to have a great claim against us because no one is going to confuse pizza with bouncing balls. So we'd probably be just fine opening up a business called Super Duper Bouncing Balls, even though Super Duper Pizza was down the street.
Okay.
But again, the rules are a little different if you're competing with what's called a famous trademark. Now, I made it sound like all trademarks that we would know about are famous, but courts actually don't automatically, just because you've heard of it, give them famous treatment. It's not that simple either. But as a general rule, it's something to be aware of, that you might have a hard time opening up your Coca-Cola, whatever you're doing, Coca-Cola printing or something. It's not going to probably work. You're going to get shut down.
Okay.
So the last thing that she asked about here is licensed products. So a licensed product, this goes back to the issue that we talked about earlier, where you get permission from a trademark or copyright holder, and they give you what's called a license to sell their products. For instance, sports teams, this is an easy way to explain this, is the sports teams don't, like, if you follow, for instance, one of your college football teams or baseball or whatever it is, the team itself is not out there marketing their products. They have given certain other companies authority to market and sell their trademarks. And so you'll see across the country shops selling New York Yankees apparel and other things like that. It's not because the shop, it's not because the Yankees are out there doing it, and it's not even because Major League Baseball is out there doing it. They have just given that authority to these different apparel shops and so on and so forth, so that it's all done hopefully properly. Sometimes those things are also knocked off illegally, but that's what a licensed product is. It's when it's done correctly with permission from the trademark or copyright holder. Usually trademark is what is at issue in terms of apparel and things like that, but it can come into play with copyright issues too.
Okay. And I know that this the person who asked this didn't ask this question, but I just thought of it. So is getting a license to create something using someone else's trademark or copyrighted material just as easy as maybe going to their website and asking, or is there some type of formal legal process for getting a licensing agreement?
Yeah, if you're going to get a licensing agreement, that's one thing I would advocate, getting the help of an attorney to do that, even if all they do is review the documents that the trademark or the copyright holder presents. But in terms of getting the process started, there's no one right way to do it. It depends on how large this company is that you're approaching, or maybe it's just an individual, but it's all a matter of negotiation. If it's a famous trademark or a well-known trademark or copyright, chances are they've been approached a lot and they already know what the answer is, and how to deal with that. They probably have a set response as to how to handle those things. If it's a smaller player, you may both be doing this for the first time and trying to work out, well, what does this look like? What are you going to allow us to do? But there's a lot of variables that come into play. Just because you have someone's permission to use a trademark on a T-shirt doesn't mean you also have permission to go and put it on a coffee mug, and so on. So you definitely want to get all those details worked out so you don't find yourself in a lawsuit down the road.
Yeah.
And you want to make sure an attorney helps you get through that process. Even if it's very simple and they just say, hey, I'll give you all the rights you want in this photograph for $500. Well, that's pretty simple to write up, but you want to make sure an attorney helps you do that.
Okay. And then with intellectual property, is it primarily restricted to, or not restricted, but limited to software or things that aren't physical? Because you're thinking up how to do something or thinking up the idea of how to do something.
Well, intellectual property includes copyrights and trademarks.
Okay.
So if you own a copyright, you own intellectual property. The other primary branch of intellectual property is patent. Any patents that you might hold. We haven't discussed that at all, and we don't handle any patent issues at our firm. But basically, the idea of patents is to protect inventions. And so there's a whole body of law that covers those things, but it protects inventors so that they can, for a period of time, earn the profits from their own creativity and the work that went into their invention. So that would be another part of intellectual property. And if that's the nature of any of your listeners and their business, it is actually inventing things that would be subject or could be subject to a patent and patent protection, they definitely ought to reach out to a patent attorney that can help them and make sure they're protected in all those ways.
Okay. All right. Okay, now the next question is also from an anonymous seller. And so it says, there are some shop owners who believe that if they have the right statement in their item description, they are safe from legal action. And the verbiage usually says something like this. This listing is strictly for our time and creative services to create your item. All copyrights and trademarks of the character images used belong to their respective owners and are not being sold. This item is not a licensed product, and we do not claim ownership over the characters used. End quote. Does having this sort of verbiage listed in the item description actually protect them from legal action from either Etsy or the copyright holder?
Good. So this kind of goes back. We talked about disclaimers a little bit.
Yeah.
The short answer is no, that it either is or it isn't an infringement. But that said, I do want to qualify it with particularly in the realm of trademark. And we'll get into this, I think, in perhaps a little bit later. But the idea is with a trademark, if you are using someone's trademark because it's the only way to express something, for instance, there was a case where the court allowed a mechanic to advertise on his website that he repaired Volkswagen automobiles. Clearly, this fellow was not a Volkswagen representative.
Mm-hmm.
He was a mechanic that fixed cars, including Volkswagens, and Volkswagen sued, saying, "Hey, you can't say that. That's our trademark." And Volkswagen, of course, was a trademarked term, and so forth. But the court said, "Look, there's no likelihood of confusion here. Mm-hmm. This fellow is a mechanic. He's not saying that he represents Volkswagen. He's not saying that he is Volkswagen. He's not saying that he can do what Volkswagen can do for you. He's just saying he can fix your cars, including a Volkswagen." So in that case, a disclaimer, might be helpful to the extent, again, this is a limited situation, because but if you find yourself in a place where you're using something, a trademark term in particular, that cannot be used in any other way, there's no other way to express it. There's only one way to say you repair Volkswagens, and that's to say that you repair Volkswagens.
Yeah.
So in that kind of a case, you would want to make it clear. Now, in a mechanic's case, I think it's pretty obvious, even without it being stated, that he's not Volkswagen. Mm-hmm. When you take your car to Joe's repair shop, no one thinks they're going to Volkswagen. So, but in other cases, it may not be so obvious, and you would want to certainly indicate to your audience, your consumers, that what they're getting is not straight from X, Y, or Z company. It's from you. Now, that doesn't solve all your problems, because if you're using it in ways that are violation of the law, having this kind of disclaimer isn't going to get you very far. But I would say this for it: it's certainly better to say that than to try to take credit for it,
right?
Or to try to create the impression, or maybe the unstated impression, that you have permission when you don't. But it doesn't solve all your problems just by putting a disclaimer up there like that.
So if the disclaimer wasn't there, would a court look at that as the seller implicitly saying that they are licensed to sell that product that has copyrighted material?
No, but it would leave, not necessarily, but it would leave the door open as to what people thought. Now, going back to that mechanic example, no one is likely to think that this mechanic represents Volkswagen. Mm-hmm. But you can see, it's not hard to imagine another scenario where people are saying, "Oh, do you represent so-and-so, or do you not represent so-and-so?" Mm-hmm. And so it could leave some ambiguity there that would certainly give some additional fodder to the company that could be bringing a lawsuit against you, to say, "Look, these customers, they had no idea that you and I were not affiliated. For all we know, they thought that you had licensed products and that you were one of our distributors," and so on and so forth. So I would say, if you are going to go to a place where you feel like you need to use something, not in the way of an infringing way, but you think it's not infringing, and I wouldn't make that conclusion unless you talk to a lawyer. Mm-hmm. But if that is your conclusion, I think having a disclaimer is imperative. Even for the Volkswagen guy, I would put it down there, even though it looks kind of silly down at the bottom of the page.
Yeah. Just
put it there and say, "Hey, I'm not a licensed Volkswagen guy. I'm just a mechanic." And your listeners here can all figure out how that might apply to them.
Yeah.
And they would say, I'm not affiliated with this, and I don't have their stamp of endorsement. This is not X company. It's just me.
Okay. So like with this particular statement, I think it's just clever, because I would have never thought to say what I was what I was selling was my time and my creative service, but not actually the copyrighted or licensed material, because it's all one package, really. So with this particular statement, is it or disclaimers in general? So this is talking about sellers who put their own crafted disclaimers. They don't necessarily protect you, but they don't hurt.
Yeah, I think that may be a fair way. In this case, again, without knowing all the facts and what's going on, I can't speak specifically to what is happening here, but let's imagine, for example, that it says they're using maybe character images, or at least the question is about character images. So let's say they're using Simba from The Lion King, and they're marketing little boys and little girls' clothes with Simba on them or something.
Right.
This kind of disclaimer is not going to save them from an infringement action, because they're basically just, like I said, putting a Band-Aid on something that has a lot more serious difficulty.
Yeah.
I mean, they're kind of almost admitting to the infringement problem, but they're just saying, that's what we're doing is infringing. So I don't think that in that situation, using the Simba on the clothing example, that would be very helpful at all to have it there. I'm not sure if it hurts, but it probably, I don't know, the court may even take a little jab at it in the decision, because it's almost humorous to put that kind of disclaimer on it, hoping that it would fix it. But again, I don't know the facts of this case. Maybe there's something that's a little bit more in the gray area that I'm not understanding from the question, in which case it might be possible to use them in that way. The issue that most of your listeners have, I imagine, is that almost all of them are selling products of one sort or another. So that's where the courts are going to be most likely to come in and defend the rights of those who have created these trademarks and copyrights. For instance, Simba, the cute little lion, he, Disney has all the rights to market little clothes and shoes and whatever else with Simba on them. And so if you're doing that, even if you have a disclaimer, the whole purpose of that trademark for Simba is so that they could do that. So it's going to be very difficult to claim that what you're doing is okay if that's the nature of what you're doing. It's got to be more subtle and more transformative than that, or just more innocent, like the mechanic who just is letting people know that he'll fix your car. To the extent, if you're trying to make a new car and put Volkswagen on the back, that's going to be a problem, no matter what disclaimer you have.
Yeah. Okay. Jared, I think we have come to the end of part 1. When we started this conversation, I didn't think we'd have to do it in 2 parts, but I think we should, because I have still a whole bunch of questions to ask you, and we're about an hour and a half in. So I'm making the executive decision to make this a 2-part episode. I think this is the first time I've ever done a 2-part episode. So thank you.
All right. Thank you.
All right. So we will be back next week. So between now and next week, if you want to get more questions in, I would recommend that you go to convome.com and go to this blog post. It will be your copyright questions answered, and post your questions on the website and I will put them all together. But if you have the patience to wait, I still have a bunch more questions that we're going to talk about next week, and yours might just be one of those. But feel free to leave a comment on the blog. I will review them and talk them over with Jared. And if there are any new questions that haven't already been submitted, we'll look at answering them in next week's episode. But for now, Jared, thank you so much for what you've already covered, and thank you for what we're going to cover in the next episode too.
Thank you, Ijama. I appreciate it. It's been great.
You're welcome. And I thank you for listening to the podcast. I will be back next week.
Thank you for listening. You can subscribe to the podcast in iTunes, and while you're there, please leave a review too. Visit convome.com to leave a comment or feedback on this episode.